Good day, ladies and gentlemen, and welcome to the Shearman and Sterling Brexit Vote Conference Call. Today's conference is being recorded. At this time, I'd like to turn the call over to today's host, Mr. Barney Reynolds. Please go ahead, sir.
Hello and welcome everyone to the Shearman and Sterling Post-Brexit Vote Update. I'm Barney Reynolds, the head of our Financial Regulatory Group. With me are my partner Thomas Donegan and also Collier Stale, both of our Financial Regulatory Group based here in London and in Frankfurt respectively. This call will run through the practical implications for financial institutions of Brexit. We've got a lot of ground to cover. Of course, there's a possibility that the Brexit vote triggers changes to the EU treaty on points of controversy that were flagged during the referendum process, such that nothing two major changes in terms of the outside world. It's more to do with the relationship between the UK and EU for internal purposes. But we'll assume that's not the case on this call. We'll instead assume that there's a more fundamental renegotiation or repositioning of the UK's relationship with the EU. So a momentous decision was taken yesterday by the British people to exit from the current arrangements with other European member states. At present, various key aspects of UK and English law are established at EU level. Most controversially, immigration from other European member states is unrestricted. With the migrant crisis in Europe and large-scale economic migration of European citizens to the UK, uncontrolled immigration has become a major concern. This is not an issue that one would immediately think of as relevant to financial services, but it will influence the likely post-Brexit relationship between the UK and the EU. Other concerns of UK citizens in the campaign involve the net amounts paid to the EU by the UK and perceived over-regulation. The clubbing together of certain states in what is seen by most economists as an inevitably federal project based around the euro currency and recent troubles in Greece have also been key issues. The pooling of sovereignty required by the Eurozone seems to be more than the majority of people in the UK would appear willing to accept. We'll now address the process for exiting the EU, including the expected time frame. Collier.
Thank you, Barney. Yesterday's referendum has no immediate effect as a matter of European law. The procedure to be followed by any EU member state wishing to withdraw from the European Union is set out in Article 50 of the Treaty on the Functioning of the European Union, the so-called exit clause. And as you might know, there's no precedent, so it's not quite clear how this will work in practice. We know that a member state wishing to leave the European Union has to notify its intention to the European Council, and then the European Council will basically negotiate withdrawal arrangements with the leaving member state, taking into account any new framework regulating the new relationship with the European Union in the future, and then this withdrawal arrangement will be signed by the European Council on the side of the EU, acting upon a qualified majority of the remaining member states. The notification of the intention to leave the European Union will trigger basically a 2-year process, which can then be used for the purposes of the negotiations. This 2-year process can be extended by an unanimous decision of the European Council and the relevant remaining member states and the leaving member states. With regard to the trigger date of this Article 50 procedure, it's not yet quite clear when this is supposed to happen. This morning, Labour leader Jeremy Corbyn has called on Cameron to invoke Article 50 immediately. However, in its speech later today, Cameron made it very clear that he will leave the task of triggering Article 50 to his successor. Hence, under this timeline envisaged by the Conservatives, the Article 50 notification would not be invoked until after October at the earliest, when Cameron is formally replaced by a new Conservative party leader, and the Article 50 notification could also be delayed further if the new party leader decides to call a general election. And this has also been confirmed in the speech of Boris Johnson this afternoon, who said that there is no hurry to make this notification. With regard to the content of the Article 50 negotiations, there might be an argument that the 2-year negotiation period only relates to the withdrawal agreement, and that any new arrangement would have to be drawn up separately, and this might take a longer time, probably another few years. I should also say that the European authorities expressed their expectation that the entire process will be triggered as soon as possible. One final word with regard to Article 50. It's also not quite clear whether any replacement arrangements, for example, any arrangement under which the United Kingdom might become a member of the European Economic Area, could be handled under the Article 50 procedure, because this is basically a discussion which has to be done with each EEA member state, and the relevant European authorities, the European Council, would probably not have the competence to deal with these issues, with these accession agreements under the Article 50 procedure. That's it from my end. I'm handing over to Thomas Donegan with regard to the implications under UK law.
Thanks, Colin. So under UK law, I think the best way to look at what happens next is to consider how we currently establish our relationship with Europe. We currently have the European Communities Act, made in 1972, which gives powers to European bodies like the Court of Justice and Commission. It makes EU regulations automatically effective in the UK, disapplies English laws which are inconsistent, and then allows directives to be implemented by secondary legislation. So that's out there, and in order to affect Brexit, that legislation is eventually going to have to be changed, either repealing it altogether or amending it such that it only looks backwards to the period while we were a member of the European Union. And that creates an interesting situation in Parliament, because most MPs support Remain. It's probably only about 25%, about half the Conservative Party, that supports exit, and that's not enough to carry an Act of Parliament. But we do expect MPs to respect the referendum outcome, at least at the moment. There might be some other parliamentary votes supporting process things like services of notice or agreements with the EU. That doesn't seem necessary from a legal perspective, but you may find other motions going through and being debated. But at the end of the day, we're going to need some kind of Act of Parliament. Another thing just to flag, European Court of Human Rights is another organ of Europe, and that's going to stay in place. That's unaffected by our exit from the EU, although there are other kind of proposals around replacing that with something more UK-centric, and that may be taken forwards with EU exit. Looking at what laws are likely to continue and which ones not, we think that most of EU law as it currently stands is likely to stay in place. That includes most of the financial services framework that's come in after the credit crunch. There may be some small tweaks at the edges. There are a number of laws that politicians and people in the UK often grumble about: the bonus cap, working time requirements in employment law, the curvature and number of bananas which can be sold in the shops, and things like this have often come up. And so there'll certainly be some things which are dropped, but we'd expect most of EU law to be grandfathered or replicated in some way. And that would include the reforms we see in MiFID II on derivatives and regulation, in EMIR on derivatives and market infrastructure, CRD4 on capital and bank regulation. We would presume would all be retained, and probably some parts of the fund regulatory regime. An interesting question is about the Bank Recovery and Resolution Directive. This is around bail-in and recovery of banks to stop taxpayer money being used and other possible solutions. There's a European-wide regime of recognition and some interesting reciprocity and recognition issues when the UK leaves. And a lot of lawyers have spent a lot of time recently on the dreaded bail-in language. And if English law becomes a non-EU law, we might need bail-in language in every English law contract. That will keep lawyers busy for a long time. But some things won't change: contract law, tax treaties, most of the choice of law stuff that we know and love. And so we don't see any major impacts on people using English law in commercial agreements or UK jurisdiction. That's obviously subject to what happens in politics. We're going to have a new Prime Minister and probably a new Chancellor before too long. We've got a vote of confidence in the Labour Party. We've got Scottish and Irish nationalists asking for new referendums on unification or separation. So it's possible that the political landscape will change and we end up somewhere else. But as we see things, we would expect grandfathering of existing laws with tweaks and some kind of parliamentary intervention to make this all happen. One word on the future. Collier touched on the EEA. One possible solution for the UK would be to leave the EU but rejoin the EEA, which would give you passporting rights and effectively require you to implement all EU jurisdiction going forwards. That would solve a lot of problems which the city would face, but unfortunately it may not be acceptable to the people, because you would also sign up to free movement of people by doing that. That's obviously been one of the most controversial areas. I'm now going to hand on to Barney, who's going to go through the impact for businesses and structuring under what may be a new regime.
Thanks, Thomas. So first of all, as a result of the European framework becoming a UK English law framework, the UK English tradition of looking at the words of the text rather than discerning the underlying purpose will prevail, which should make the laws more predictable, and that in fact has been one of the things the UK has been complaining about. In terms of the financial architecture, the architecture of the financial markets in Europe from a legal and regulatory perspective, what I'm going to focus on are the key points for banking or banks and investment banks in the context of investment banking or investment businesses, as we call it, i.e. people engaged in principal and agency broking and dealing, custody, depositories, derivatives traders, asset managers other than those operating under AIFMD, which is a sort of minority sport for most. So general asset management and investment advice. Now the law as it stands, set out in something called MiFID, works as follows. And what I will come on to is the sort of worst case scenario, which is an amended version of this law that is going to apply by the time of any Brexit case. Notably, in order, and the reason for doing that is to give people an understanding of the possible impacts of Brexit and to inform any contingency planning. And notably, the implications of this scenario are nothing like as stark as have been portrayed by some, and any negotiated solution is likely to be considerably better than this and to involve some of the sort of renegotiation ingredients that Thomas and Collier have talked about. Historically, most financial institutions headquartered outside Europe have set up subsidiaries in the UK, predominantly the UK, and obtained a passport under MiFID, or if they're banks, the CRD4, as it is now, to conduct business across Europe. And the passport, by and large, almost entirely covers investment business. If it's MiFID, it covers investment business in its entirety. If it's a bank, a credit institution, most of the passport covers investment business. A very broad view of what is cross-border has been adopted by lawyers in the market, since it was really a cost-free matter to make a European passport notification. However, much business is not in fact cross-border under European law. For instance, deposit taking, one of the key activities of a credit institution, is seen as a matter of European law to take place by where the books and records of the deposit-taking bank are located and therefore isn't cross-border. Further, large amounts of business in the city takes place through dealings with others who are also located in the city and therefore isn't cross-border. Where bankers fly into other European countries and advise people there, or, and this is more arguable, where they provide advice by phone or email, a passport is seen currently as necessary. The same is largely true for the provision of other services where contact is made on an outbound basis from the UK. However, no real rigour has been applied to the question of whether phone calls, emails or other such activities were genuinely cross-border as a legal matter within Europe due to the ease of making the passport notification to the regulators. So notifications were the default for many activities which were not in fact cross-border at all. Going forward, the analysis of what is actually cross-border or takes place in the city will need to be far more legalistic and rigorous. Now, this existing setup is being modified at the beginning of 2018 by MiFID II, a revamped version of MiFID, which comes into effect then, before the earliest date, most likely, that Collier mentioned for any genuine Brexit, which would be October 2018. Until that time, of course, the current laws apply, nothing changes at all. As from that time, under MiFID II, there are two passports provided for in MiFID II for institutions which are not incorporated or based in the EU at all in the context of wholesale investment business, i.e. principal and agency broking and dealing, custody, fund management, for those not relying on AIFMD, and investment advice with professionals or more sophisticated investors. One of those passports involves a registration with the European Securities and Markets Authority, ESMA, and the other involves the establishment of a retail branch in certain European member states. And paradoxically, or perhaps surprisingly, through establishing the retail branch, one gets a wholesale passport throughout Europe. These two types of passports provide a framework for US firms and other so-called third country firms to have access to the European markets. There's no reason why the UK would not be able to use the same arrangements, and in fact, due to its laws being aligned entirely with the EU's laws, the process of recognition should be relatively automatic. MiFID II, as I've mentioned, comes in at the beginning of 2018, and across within Europe and as regards third countries introduces these measures. In order for the passports to be available, the Commission has to have made a determination, if the UK, or as soon as the UK is out, that UK laws are broadly equivalent to those in the EU. Because the UK's laws have a common ancestry and are in fact identical to those in the EU, the determination should be simple. There's also a requirement that the laws are properly enforced, but again, since the UK's regulators have hitherto been colleague regulators, that requirement should be satisfied as a legal matter also. As an example of what equivalence means, equivalence determinations in the context of the derivatives regulatory framework, EMIR in Europe, don't in fact, and have been shown not to have required identical laws, but merely laws giving rise to similar outcomes. So in the EMIR context, which is already up and running, equivalence determinations have already been made in favour of the US, Hong Kong, Singapore, Canada, Mexico and other countries. US regulations, as an example on derivatives, are quite different in many ways from the EMIR regulations, but were nevertheless recognised. There was a bit of a spat over 1 or 2 day margining, which was a big point of economic differentiation, which has been resolved by accommodation on both sides. There are equivalence rights in existence already in Europe under European law for third country, therefore UK, exchanges, central counterparties and other market participants. These have been extensively negotiated, particularly with the US, but would apply more generally anyway, and they would apply to the relationship, therefore, between entities established in the UK and those in the EU. There's no equivalence regime for certain types of business line, such as cross-border lending, but in that case, Arrangements have been developed for instance, hedge funds to engage in that business outside the relevant framework entirely, which demonstrates the considerable latitude available. All of this discussion in relation to the MiFID II passports assume that there's no special deal negotiated for the UK, which is at odds with the likelihood of the situation and the requirement under Article 50 for a negotiated arrangement between the EU and UK before termination takes effect. In reality, there's likely to be a stronger set of rights flowing both ways in the financial markets between the UK and EU and vice versa. In determining the likelihood of a broad deal, one issue to look at is access to the UK by European banks. EU institutions currently operating in London through a branch passport, and there are numerous of those, some of them relying very heavily on branch passports, could be required to establish much more expensive subsidiaries in the UK, not dissimilar to the way in which the US IHC requirements operate, if reciprocity is not achieved in negotiations. Similarly, cross-border access could be made subject to a license. The UK's position is also, of course, subject to a wider trade relationship of considerable importance to various EU member states. As a result of all this, we'd anticipate ultimately a more subtle and sophisticated arrangement being established between the UK and EU involving most aspects of business currently carried on with the EU member states being carried on in much the same way as it is now. In relation to euro clearing, there's a possibility that the ECB will seek again to require such clearing to take place within the Eurozone, though quite how they could succeed in effecting that in practice remains to be seen. US dollar clearing takes place in London without any issues, and ex hypothesi, the ECB rules that they may promulgate over euro clearing will have no jurisdiction or impact in the UK over a post-Brexit UK setup. We appreciate that this is all a very complicated area and that numerous subtleties arise. The entire Shearman and Sterling team continues to be at your disposal over the weekend and, of course, going forward for any clients who wish to discuss the matter. And please continue reaching out to your usual contacts or to one of us if you'd like to talk about it further.